Last Friday, the state's highest court ruled that some pretrial detainees not charged with violent crimes can be released from jail. The American Civil Liberties Union of Massachusetts, as well as 2 defense lawyer associations, filed a petition to release even more prisoners due to the COVID-19 pandemic. Hampden District Attorney Anthony Gulluni joined 7 state prosecutors arguing against the broad release of prisoners because of what they deem to be a public safety risk, in addition to a lack of services to support people re-entering the community. He spoke with Carolee McGrath to offer his perspective.
So the SJC decided on Friday that essentially what had been proposed by the petition of CPCS and the Mass Commission of Defense Lawyers was really not appropriate. That petition requested essentially the blanket release of potentially thousands of inmates, both pretrial and sentenced inmates. The SJC's decision was really along the lines of what we 7 district attorneys, some other parties to the lawsuit had argued, and that was a case-by-case, individualized analysis of those who are held to determine whether they first and foremost do not pose a significant public safety risk, do not pose a risk to victims, and given their backgrounds and so forth, and their health conditions, whether they were an appropriate person for release under these conditions. And what I would like to point out is we had begun this process a couple of weeks ago in my office, really making individual determinations, especially if someone was presenting with a medical history or an age-related issue that made them a higher risk were they to contract COVID. So we really, certainly myself and the other DAs and other parties opposing this petition were really focused on a more holistic picture, public safety first and foremost, victims' rights, as well as the health and wellness of those incarcerated.
Okay, so this is really for pretrial detainees who are nonviolent, yes?
Correct. The SJC decision decided that because of the separation of powers, they couldn't do anything relative to sentenced inmates. So their decision really does focus on pretrial inmates. There's, as everything in the legal field, it's a bit complicated, but you're right. It's essentially those who are nonviolent who have an opportunity to be released given the COVID crisis.
Okay, and the court also asked you to look at expediting parole as well?
Right, so any parole issue falls under the parole board, which is under the executive branch. So the parole board was essentially asked very nicely by the SJC to expedite their processes. They had a number of individuals who had been approved for parole but had not been released. So the SJC, knowing that, given the circumstances again, asked the parole board to act as quickly as possible with those people.
You mentioned a little bit that you had already begun this process. So how, as you move forward, do you comply with this decision?
Again, really our office had been doing this, much of what the SJC has ordered. So we've appointed point people within my office. We've developed good communication, good lines of communication with the defense bar here locally and with our court partners, the trial court, probation, et cetera, to make these determinations thoughtfully, again, considering public safety, but also considering the threat that this poses to people who are incarcerated. What the SJC decision decided also is that these kinds of hearings have to be heard within 48 hours of the filing of the motion. So obviously there's a sense of urgency, I think, on the part of all parties to make sure that if someone is appropriate to be released, someone has an age-related concern, a health concern, we want to get these folks out and keep everybody safe.
So the ACLU who filed the petition, or was one of those who filed the petition, said this doesn't go far enough, and they had talked about those who are sentenced, including those with an underlying health condition, somebody with an age concern as well. What's your response to that?
Well, it really, I think, just has a singular focus. I think what the SJC decided, our highest court in Massachusetts, and I think what we were arguing from the very beginning is the health and wellness of inmates is incredibly important, and we're very compassionate and sensitive around those issues. But given the Victims' Bill of Rights, which is a statutory right given to victims in this Commonwealth, and given the concerns of public safety, Carolee, at a time when police departments and public safety is stretched very thin. Medical services are really operating at 100% capacity. The court system is down really for all intents and purposes, that releasing people who are not prepared. Let's be mindful of that as well. And that was a part of our argument that typically when someone is released from custody, that person is planning with the jail or house of correction in which that person is housed to get released, to have housing, to have medical services, to have a place to stay. This really called for the spontaneous release all at once of thousands of inmates. And we really thought that was unwise, not only for public safety, but also for the very inmates being released, because there was no planning and it was setting many up really for disaster. So I think the SJC decided, along with our thinking, that this really needed a global, holistic consideration. And what the petitioners put forward was really a singular, narrow focus, and I thought was very much ill-conceived.
One of the other points that they had brought up was releasing people 6 months prior to their eligible date. Obviously, that would go into the whole category of you saying releasing thousands of people who might not have those services. Obviously, that's not something you're a fan of?
Well, I wouldn't say that, because my office now has released upwards of 24 individuals by agreement. And this comes well before the SJC decision, many of those. Because those who are wrapping up sentences close to being released, especially those with, again, age-related concerns or health-related concerns, we were agreeing that they should be released. They shouldn't stand that risk of being incarcerated. I do want to note that the Department of Correction across the Commonwealth, as well as here, our sheriff, both have done a terrific job of protecting those in their care and custody. In the Sheriff's Department, there are 0 cases of COVID-19 in all the facilities of the Hampden County Sheriff's Department. They've taken really robust measures to protect people, both their employees and those incarcerated. So that was a part of the argument, too, that many people are really safe and healthy within the 4 walls here in Hampden County. And I think that's very significant. But we're making thoughtful decisions considering all the circumstances. And again, we're releasing 1, 2, 3, 4, 5 people a day by agreement, because we understand these risks. But to let out a huge group on a categorical basis of inmates really was a very dangerous thing, and we're glad the SJC agreed with us.
You know, defense attorneys have said that while the prisons have said and the jails have said they're taking all of the necessary measures to keep people safe, it's almost impossible to do that in that environment. They said in their brief that it's, quote, a petri dish for the rapid spread of infectious disease. How do you respond to that?
Well, the jail facilities across the Commonwealth, as well as Department of Correction, all submitted affidavits. I can speak to what is the situation here in Hampden County, and there are 0% of inmates who sleep within 6 feet of another inmate. They all eat with 6 feet space between them. So essentially, social distancing is the rule in the Hampden County Sheriff's Department. So some of that sensationalistic language really is not appropriate, at least in certain situations. Again, I laud the jail facilities here and across the state for really taking very aggressive and early measures to protect their inmates. And again, there has to be a consideration of how this impacts public safety. That petition essentially would have opened up the doors to all kinds of different inmates. And if you read that petition, it's in black and white. If someone were over the age of 50 or had a pre-existing condition, whether that person is convicted of murder or rape or domestic violence offense, et cetera, that person was going to be presumptively released. That was the terms of the petition. So I thought it was an overly broad and really ill-considered filing. And again, the SJC agreed with our position that individual hearings, considering all the factors, must be the way to do this. And we have to consider victims' rights and have to consider public safety, as well as the wellness of inmates as they're housed. So the SJC made, I thought, a very intelligent, a very thorough decision that I think considers all those things.
And obviously you are representing victims. What are you hearing from them about this movement really across the country of looking at releasing people early?
The conversations that my staff and I have had to a limited extent, given everything that's happening with victims and victims' families, it's the same concerns that when you talk about a sentenced inmate, a victim or a victim's family is informed that this person is going to be sentenced for X number of years. This person will be incarcerated for this period of time. So sort of not to worry. And if anything were to change about that, whether it's parole hearings or something else, you're going to be informed and you're going to have notice and you're going to have your statutory rights observed to know what's happening and to be able to say your piece should that be appropriate. This would have completely trampled over those rights of victims. So I think there was a measure of shock. There was a measure of disbelief that how can this be really on the table here? But fortunately, we don't have to deal with that situation given the Supreme Judicial Court's decision, and victims' rights are preserved through this decision.